Hello everyone, welcome to another episode of our channel Low Point. I'm Zanisha Babu. It is easier to get married, but it is more difficult to get divorced. Under Hindu law, marriage is considered as sacramental and is supposed to be eternal union of two people.
Whereas divorce or legal separation is considered as a big taboo.
We have a Supreme Court of India's advocate on record, Adv.Praseena Elizabeth Joseph, to explain the law related to marriage and divorce under Hindu law. So let's watch.
Hindu Marriage Act of 1955 deals with Hindu marriage and divorce. According to Graha Sutra, Vivaha or marriage is considered to be the most important sacrament, a union of two personalities for the protection and maintenance of society by practicing self-restraint, reciprocal cooperation and self-sacrifice. General essential conditions of marriage are applicable to Hindu marriages as well. Now let's see what are the essential conditions of Hindu marriage. First of all, bridegroom should be of 21 years of age and bride should be of 18 years of age at the time of marriage. Secondly, parties to the marriage must be of sound mind to enter into marital relationship. Thirdly, a Hindu cannot marry a second time when his first wife is alive and is not divorced. Further, an essential ceremony of Hindu marriage is Saptapadi, wherein the couple takes 7 full circles walking clockwise around the sacred fire, representing 7 principles and promises they make each other, wherein the last step marks the completion of the ceremony. Another important condition of Hindu marriage is that couple should not be within prohibited relationship. Prohibited relationship means a Hindu cannot marry from his close relatives within the family. That means a Hindu cannot marry spouse of his father, grandfather, mother's brother, etc. A Hindu cannot marry his siblings, uncle, aunt, nephew, niece, etc. and children of brothers and sisters cannot marry each other. However, there is an exception to this rule. If the local custom existing from time immemorial permits this above relationship, then the custom will prevail over the Hindu Marriage Act. That means, though the marriage is within the prohibited relationship, because of the backing of the custom, the marriage is considered as valid. For example, marriage between maternal uncle and niece as well as marriage between cousins, that is children of brother and sister, are allowed in some of the local customs. So wherever the local custom is prevailing, there, though the marriage is within the prohibited relationship, it is considered as valid. Hindu Marriage Act provides for punishment in case the married couple is within the prohibited relationship. They are either supposed to pay Rs 10,000 as fine or 1 month imprisonment or both, as the court may deem fit. We have seen that divorce is the legal separation of a married couple. However, divorce can be obtained only on specific grounds. Now let's see what are the various grounds on which the couple can get divorced. First of all, adultery. If the husband or wife is having extramarital affair with somebody other than the spouse, then it is a valid ground for divorce. Secondly, treating the spouse with cruelty. Cruelty includes mental cruelty, physical cruelty, or both mental and physical cruelty. Physical cruelty includes beating, slapping, kicking, etc., causing physical pain and harm to the spouse. Mental cruelty includes psychological harassment by demanding dowry, using abusive language, ill-treating the parents of the spouse, relatives, etc. Another ground for divorce is desertion. Here, one of the parties to the marriage is willfully neglecting the other without a valid reason and without the consent of the other, and for a continuous period of 2 years, both of them are living separately and without any communication. Then the deserted spouse can file a petition for divorce. If a Hindu husband or wife converts to another religion and ceases to be a Hindu, then the Hindu spouse can file a petition for divorce on this ground. Mental disorder of the spouse is another ground for divorce. Abnormal, aggressive, violent behavior which cannot be tolerated under normal circumstances or causing harm or apprehension to danger to life are all considered to be forms of mental disorder. If one of the parties to the marriage is suffering from sexually transmitted disease like AIDS or any communicable disease, then that is another ground for divorce. Pronunciation of the word is another ground for divorce, wherein party to the marriage renounces the world by withdrawing from worldly pursuits to lead a non-secular life. Then the other spouse can file a petition for divorce on this ground. Another ground for divorce is presumption of death. If party to the marriage is no longer being heard of as alive for a period of 7 years, then on this ground, husband or wife may obtain divorce. Finally, a specific ground for divorce to the wife is if husband is guilty of rape, sodomy, bestiality, even a single act of rape, sodomy or bestiality, then it is a sufficient ground for the wife to seek divorce from the husband. Thank you.
Thank you for watching. Stay tuned. Till then, take care. Bye-bye.